And welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular set of videos, we're talking about family-based visas. Now, I have lots of clients who come in or who send me emails saying, that they have a petition from a fourth preference petition, for example, a U.S. citizen sister or brother, and are they prohibited from doing anything else, or what else can they do? And the answer is no, they're not prohibited from doing anything. So for example, you have a fourth preference petition that takes 20 years or 15 years depending what country you're on to become current, and let's say they get an employer that petitions them for a PERM, which is an employment-based visa, and that only takes, depending, 3 to 5 years. Absolutely, get the PERM going too. So it's really, when you look at it, these different petitions are like horses going around the track. The first one to the finish line wins. So they could care less if you have I-130 petition from a sibling and a PERM from employer A going at exactly the same time. One does not invalidate the other. By the same token, one doesn't make the other go faster either. They each go on their own separate way. One goes to the family-based adjudication unit, another goes through its procedure to ultimately the employment-based unit, and we go from there. The only issue really is, which a lot of people are unaware of, is if a lawful permanent resident petitions a son or daughter, that's fine, and that takes several years. But then what happens is the son or daughter gets married while the parent is still a lawful permanent resident. There is no such type of petition, and therefore that petition is immediately declared void. So be sure you don't get married in that particular case so that it can go forward. Okay, more in the coming videos.